ሰላም ጤና ይስጥልን። ወደ የኢትዮጵያ ስኩል ኦፍ ላው ቤተሰቦቻችን እንደምን ቆያችሁልን? በክሪሚናል ፕሮሲጀር ክላስ ተመልሰናል። አብራችሁ
we considered how police investigation activities are carried out. Immediately the police arrests the suspect. They have to brought the suspect within 48 hours, we said. And the time taken from the place of arrest to the journey, the time taken from the journey generally, from the place where the person is arrested to the courts will not be calculated, it says. Because the understanding is that sometimes it may be inconvenient for the police to immediately take the arrested person to the nearby court. So the arrested person has to be taken within 48 hours. This is a very important guarantee. So the person after being arrested, whenever he is brought to the nearby court within 48 hours, we question what will follow. What will follow? What will the court do? What will the court do? In other jurisdictions, I hope you have seen the article that I sent you, written by, I don't think you can read it. The article written by Fisher, he has written a very good, a very interesting article on the process of post-arrest pre-trial screening process. Okay? In other jurisdictions, both in continental and in common law jurisdictions, there is what we call post-arrest pre-trial screening process. This process is very essential because whenever a person is brought to the court after arrest, the court will consider the legality of arrest. The court will consider the legality of arrest. Whether the crime was actually committed and whether there is prima facie case that justifies the police to arrest and to proceed on the case. Okay? Is this based on the justifiable ground that the police arrested the person? Is there any prima facie case against the person arrested? That justify charging and the subsequent proceeding? Okay? This is what we call post-arrest pre-trial screening process. So, if the court considers that there is no justifiable ground to arrest that person, then the court will release that person. The arrested person has the possibility of being discharged in both continental and common jurisdictions. So that is why Fisher in the article questions the Ethiopian criminal justice system is different from both the civil law and the common law traditions. The criminal procedure code followed an eclectic approach to codification, he said. He used an eclectic approach, It hasn't relied on consistent legal system in drafting the criminal procedure code, taken from here and there. So there is a problem. There is a problem in drafting the criminal procedure code. Okay? So there is no, in the Ethiopian criminal justice system, there is no post-arrest pre-trial screening process. Actually, before making such conclusion, we started looking at Article 59. Actually, it is Fisher who concluded that there is no post-arrest pre-trial screening process in the Ethiopian criminal justice system. So let us prove whether the assertion that is made by David Fisher is right or acceptable or not. Is there post-arrest pre-trial screening process? We will see. And we started looking at Article 59. Whenever a person is brought to the new court within 48 hours, we have seen what the court will do. The court will do whether the person has to be released on bail or he should be remanded. This is the thing that the court considers. And the public, in many cases, police may request the court that he hasn't finalized the investigation so that he should be given additional days for investigation. In practice, if the court grants additional days for investigation, the issue of bail will not be considered. It is after the police finalizes the investigation that the issue of bail will be considered in practice. Mind you, this is not supported by the law. The law doesn't say that the issue of bail should be considered after investigation is finalized. But in practice, whenever police says that I haven't finalized the investigation, the issue of bail after all is not considered in many cases in practice. But nowadays there is a pressure by pressure by by both in academia and in practice, okay, that bail should be considered even at that stage. Anyhow, if the police requested the court that he hasn't finalized the investigation, additional days for investigation will be given, we have considered. And the maximum days that the court will give is 14 days. But it has a possibility of being renewed. On each occasion, it says, the provision says, on each occasion. So there is no check on the police. The court cannot say, for example, I will not give you additional days for investigation because you should have finalized the investigation by this time. There is no such check on the police by the court. It's a very serious problem on the criminal procedure code. So we question whether the court can consider the legality of arrest, for example. The court can consider the legality of arrest, and many of you argued that that is unjust. The court should have played the role of playing post-arrest pre-trial screening process. And you have also raised the constitutional provision of Article 19, for example. But for your knowledge, let me just bring you to attention that there is what we call the procedure of habeas corpus. There is a procedure of habeas corpus. So this procedure is dealt under the civil procedure code. There are provisions on habeas corpus, and you do not find those provisions in this criminal procedure code. You do not find these provisions. Provisions on habeas corpus are provided in the civil procedure code. And under Article 19 of the criminal, the Federal Constitution, of course, there is a provision of habeas corpus requiring, guaranteeing the right of arrested persons to request the court for the release of their person. That is what we call habeas corpus. But habeas corpus, what you should be clear with is, it is a right claimed by an arrested person who hasn't been brought to court within 48 hours. If you are not brought to the nearby court within 48 hours, in accordance with Article 19 of the Federal Constitution and Article 29 of the Criminal Procedure Code, you can apply habeas corpus. You can apply for habeas corpus. If you haven't brought within 48 hours, mind you, so you will apply to the court that you should have been brought to the nearby court within 48 hours. Maybe you are in a secret detention, for example, or maybe you are in a police detention, no, whatever. But you haven't been taken to the nearby court within 48 hours. So, if you haven't brought to the nearby court within 48 hours, immediately after arrest, then you have the right of habeas corpus. But it is different from this one. You should be clear with this. This one, in this case, under Article 59, the person is brought to the nearby court within 48 hours. Then it talks about the procedure. Whenever a person is brought to court, what procedures will follow, Article 59 has provided. But habeas corpus provision is different. That person is not brought to court at all. But through application, he asks the court that he should have been brought to court and he should be released because he has been illegally detained. He has been illegally detained. So then, by using these provisions of the Civil Procedure Code, there is a possibility for the court to grant the release of a person. The court, in habeas corpus proceeding, can order the release of that person. But this is not the case for a person who is brought to the court within 48 hours. So there is such distinction, procedural difference. Okay? There is procedural difference. So is it fair? I mean, if that is the case, then you may prefer not to be taken to the court because in this case there is a provision. There is a possibility for you to be released by the court. Because the legality of your arrest is going to be considered by the court in case of habeas corpus, but that is not the case here. But still the problem is that habeas corpus provisions are our courts are very unfamiliar with these habeas corpus provisions. It is very poorly practiced. Habeas corpus is very poorly practiced, by our courts. And, even our lawyers and accused persons or arrested persons are not familiar with this procedure. Even I have interviewed judges and they say, oh, we have never, some judges who worked for a long period of time as a judge at the High Court in Oromia, mind you. They say, one of them told me that he has never, faced any case of habeas corpus. And I asked him why. And he said, there is a problem within the structure of the court. In the court by itself, the judges say, no, this is a civil case, this is a criminal case, Even the matter is not settled within the court itself, within the court. But it is nowadays, very recently that we began hearing about habeas corpus provisions. It is not well practiced by our courts. It is not well practiced. But the law has provided. Okay? If anybody is illegally arrested and he is not taken to the court within 48 hours, there is a right of habeas corpus. And it has also a constitutional backing. That is something that I want to bring to your attention. Okay. Now, let us check. So, by virtue of Article 59, it is very unlikely for the court to order the release of a person. What the court will consider is the issue of bail. And the police will ask additional days if police hasn't finalized investigation. But if police has finalized investigation, then the issue of bail will be considered. So if the person is released on bail, he is lucky. Otherwise, if the offense doesn't entitle the person to be released on bail, then he will remain in detention. He will be detained. That is what we call detention. And if the police says he hasn't finalized investigation, then the court will order additional days for investigation and the person will be remanded. The person will be remanded. So that person sometimes called is remand prisoner. Sometimes in some literatures you will find this term, remand prisoner. Then he is remanded. Sometimes they call it remand in some in books. You will find it remand prisoner. So this remand prisoner is a person against whom police investigation is not yet finalized, and as a result, the court ordered him to remain in the police detention center. That is what we call remand and remand prisoner. Okay. All right. So now let us check whether the other step, what we call preliminary inquiry. Very recently, this procedure has been active. By the way, previously, before the recent cases, I heard that preliminary inquiry was very rarely used. But nowadays, courts have become active. Public prosecutors have become active in using preliminary inquiry. So we will see two things. One, why preliminary inquiry is carried out, what is its relevance. Two, whether preliminary inquiry serves for post-arrest pre-trial screening process. Because preliminary inquiry is a procedure that takes place before trial. It is a pre-trial procedure. Okay? It is a pre-trial procedure. So, will it serve as a post-arrest screening process? Post-arrest pre-trial screening process? It means, will it serve to screen out whether the accused was arrested on a legal basis or not? To screen out whether there is a prima facie case against the arrested person? Does this procedure play this role? Because in common law jurisdictions, as I said before, in common law jurisdictions, courts will not be overburdened by, irrelevant cases. Before the trial, there is post-arrest pre-trial screening process. The accused immediately being the arrested person, after arrest, will be immediately be taken to the court, and the court will consider the legality of arrest. The legality of arrest, whether that arrest was based on a genuine ground, whether there is a prima facie case, that may bring conviction, sufficient case, tangible ground, is there any tangible ground, prima facie case? Is there any lawful ground for arresting that person? These issues will be considered before the trial, whenever the person is brought by court. So courts will screen out, you see, screen out. So if the court believes that there is no justifiable ground, then the person may be released. So that every case that reaches the police will not reach the court. So it has a number of advantages. One, the court will not be busy of in many cases. I mean, cases will be screened out, then screened cases will go to the court. At the pre-trial stage, cases will be screened out. So it has a tendency of reducing the congestion of cases. Secondly, it is advantageous for the arrested person. So the arrested person will not be forced, to go through the trial process. At the pre-trial stage, the case will be screened out and he may be released. So it is very advantageous for the accused persons, for the arrested persons. Benefits the court, it also benefits the arrested person. Okay? So, but we are checking if this procedure is available. We have considered that Article 59 doesn't serve this purpose. Now let us see whether preliminary inquiry is serving this purpose. Preliminary inquiry. Nowadays, which is very famous, which is very, very famous and widely practiced recently. But even though it was included in the 1961 Criminal Procedure Code, it was very rarely used. Then what is the benefit of preliminary inquiry? Okay, go to Article 80. This provides very important elements for preliminary inquiry. Very important elements. So because it provides a principle. Okay, so particular reads, where any person is accused of an offense under Article 522, this is the old penal code, so it is the equivalent provision under the criminal code is 539. It is an aggravated homicide, or what we call homicide, the first degree. Or Article 637, it is also the old penal code. Now it is 671. 671 of the criminal code. It is aggravated robbery. A preliminary inquiry shall be held under the provisions of this book. So preliminary inquiry in this case is mandatory. You can understand. So whenever homicide in the first degree, okay, or aggravated robbery is committed, preliminary inquiry shall be held, it says. Preliminary inquiry shall be held under the provisions of this book. Provided that, look, there is an exception. Provided that nothing in this article shall prevent the High Court from dispensing with the holding of a preliminary inquiry, where it is satisfied by the public prosecutor that the trial can be held immediately. Okay? So, it may be dispensed. It means preliminary inquiry procedure may be skipped. It may be skipped. Preliminary inquiry procedure may be skipped. When? Provided that nothing in this article shall prevent the High Court from dispensing with the holding of the preliminary inquiry, when it is satisfied by the public prosecutor that the trial can be held immediately. The trial can be held immediately. So you see, if the court is satisfied by the public prosecutor that the trial can be held immediately, the court may dispense with the holding of a preliminary inquiry. The court may dispense the holding of a preliminary inquiry, or the court may skip the holding of a preliminary inquiry so that the trial will continue without a preliminary inquiry. It is when the court is satisfied by the public prosecutor that the trial can be held immediately. Then what does it mean? Why? But you will gradually understand. But if the court is satisfied, if the court is not satisfied, that the trial will not be held immediately, the court is not satisfied that the trial will be held immediately. I'm sorry. The court is not satisfied that the trial can be held immediately. In this case, if the court is not satisfied, preliminary inquiry will proceed. Otherwise, if the court is satisfied that the trial can be held immediately, then there will not be preliminary inquiry. There will not be preliminary inquiry. This is the point that I want to grasp. The other point is preliminary inquiry. In other cases, if the court is not satisfied, then if the court is not satisfied that the trial cannot be held immediately, then there will be preliminary inquiry. So the offenses are, aggravated robbery and homicide in the first degree. Okay? So, assuming that I am a presiding judge of the High Court. I am a presiding judge of the High Court. Okay? Then assume homicide in the first degree has been committed. So in this case, the law provides that there has to be preliminary inquiry. There has to be preliminary inquiry. So the High Court, the case is handled by the High Court because this offense is under the jurisdiction of the High Court. By the way, preliminary inquiry occurs on offenses that are within the jurisdiction of the High Court. Preliminary inquiry is carried out for offenses which are within the jurisdiction of the High Court. But it doesn't mean that preliminary inquiry will be carried out by the High Court. We will see that. Okay? So, if I am a presiding judge, then I will ask, homicide in the first degree has been committed. So I will ask the public prosecutor, or the public prosecutor will explain to me that the trial can be held immediately. The public prosecutor will convince the court on application or on oral explanation. The public prosecutor will explain to me, to the presiding judge of the High Court, that the trial can be held immediately, so there is no need of holding a preliminary inquiry. He may ask. So I will see the evidence, the progress of the case. Then, if I am convinced that yes, the trial can be held immediately, then I will authorize that there shouldn't be preliminary inquiry, because the trial can be held immediately. So if I think that it may take some time for the trial to take place, then I may say that no preliminary inquiry shall be carried out. I may not allow. Okay? So this is what Sabbaticulant provides. In all other cases, preliminary inquiry in respect of these two offenses is mandatory. Right? So ስለዚህ ምንድን ነው አቃቤ ሕግ ለፍርድ ቤቱ ያስረዳል። እነዚህ ሁለት ወንጀሎች ከተፈጸሙ preliminary inquiry ግዴታ ነው ይላል። homicide in the first degree እና aggravated ተቃዋሚ preliminary inquiry ግዴታ ነው። But አቃቤ ሕግ, if the public prosecutor convinces the court that the trial can be held immediately, I have finalized everything. So the trial can be held immediately. If the public prosecutor convinces the court, then preliminary inquiry may be skipped or dispensed. So that without preliminary inquiry, in respect of these offences, without preliminary inquiry, the trial will proceed. So this is an exception. Otherwise, in all other cases, if the offense relates to these two offenses, preliminary inquiry is mandatory. Preliminary inquiry is mandatory. So this is the point. Please. Yes. I will come to that. Don't worry. We will come to that. Okay, so Article 2. This point is clear. Please. Yes. There is no detailed standard, but what the court will do is the court will examine the progress of the public prosecutor, the progress of investigation. So the court will make an assessment. Okay, what evidence is left? Is it ready? Is it ready for the charge to be carried out? Okay, is it police investigation? Is it properly investigated and finalized? Obviously, we will come to that. There was a controversy very recently concerning the people very recently following the days of artist Hachalu Hundessa. A number of people were arrested, and a number of trials, are taking place, isn't it? Concerning that, there was a debate. Question was raised before the court regarding the procedure of preliminary inquiry. We will come to that. Anyhow, what the law provides is If the court is satisfied with the progress of the case that the trial will be held immediately, then the court will not allow preliminary inquiry to be carried out. What the court will do is it will assess the evidence gathered by the public prosecutor. So if there are gaps in the gathering of evidence, if critical evidences are not fulfilled, in the opinion of the court, if the court believes that it may take some time, okay, to institute the case, then the court will not allow. The court will not allow the dispensing or the skipping of the preliminary inquiry, and it will bind the public prosecutor to hold the preliminary inquiry. All right. So it is personal assessment of the judges of the case, because they are also professionals, and they will assess the evidence. Otherwise, there is no detailed standard of that. Very good point. Any other holders for offences that are triable by the High Court? Okay? Whenever the offences are not under the jurisdiction of the High Court, then there will be preliminary inquiry. But this is not the case in all cases. I will come to that. If the offences, these offences, by the way, are offences under the jurisdiction of the High Court, in respect of these offences, preliminary inquiry is mandatory, except, as I said repeatedly, the public prosecutor convinces the court that the trial can be held immediately. So, preliminary inquiry may be skipped, even if the offences are these two offences. In other cases, preliminary inquiry is mandatory in respect of these offences. But, in respect of other offences triable by the High Court, it is the discretionary power of the public prosecutor, as I will come right now. Okay? Okay, let's see provisions and it will be clearer. Then you will ask me, because you are asking me premature questions. Okay, so Article 2, where any person is accused of any other offense triable only by the High Court, no preliminary inquiry shall be held unless the public prosecutor under Article 38 be so directed. You see? So, where any person is accused of any other offense triable by the High Court, mind you, still, preliminary inquiry, will apply in respect of offenses triable by the High Court. So, in respect of other offenses triable by the High Court, preliminary inquiry is not mandatory unless the public prosecutor so directs in accordance with Article 38 sub-article B. We have considered at the beginning powers of the public prosecutor. Powers of the public prosecutor under Article 38. Go back to Article 38 very quickly. Action by public prosecutor on receiving report. Mind you, it is a subsequent provision to Article 37. Article 37 says whenever police finalizes its investigation, police will forward the investigation report to the public prosecutor. Police will forward the investigation report to the public prosecutor. So, on receiving the investigation report, under Article 38, it provides the discretionary powers of the public prosecutor. It is Article 38 provides the powers of the public prosecutor. Powers of the public prosecutor. Powers of the public prosecutor. Article 38, action by public prosecutor on receiving report. On receiving the report under Article 37, the public prosecutor may, so Article A, prosecute, so the term may indicates its discretionary power. It doesn't say shall. It says may. So it shows it is a discretionary power. So the public prosecutor may, so Article A, prosecute the accused on a charge drawn up by him under Article 190, 109 up to 122. So the first option, the first power of the public prosecutor is prosecuting. So he has discretionary power. He has the power. So on receiving the investigation report, the public prosecutor may say that, oh, this is a very full evidence, so I shall investigate, I shall prosecute the case. So the public prosecutor may decide such. And sub-article B orders that preliminary inquiry be held under Article 80 up to 93, you see. So the second power of the public prosecutor is ordering preliminary inquiry to be carried out. So this is the power of the public prosecutor. So the public prosecutor may feel that preliminary inquiry should be carried out. But when? We will come to that. When? But this is the power of the public prosecutor. So the public prosecutor may decides that preliminary inquiry should be carried out. Sub C, order further investigation. The public prosecutor may order the police to finalize the investigation. The public prosecutor is a professional in looking at the report may say that these things should be clarified, ordering back, referring back to the police so that the investigation should be finalized. So this is the other power of the public prosecutor. Refuse order further investigation. In sub-article D, the fourth one, refuse to institute proceedings under Article 42. The public prosecutor may refuse to institute proceedings because of the grounds listed under Article 42. There is insufficient evidence. Even no need of ordering further investigation. The evidence is too weak, so that further investigation shouldn't be carried out, and prosecution shouldn't take place. That is the power of the public prosecutor. Or Article 42, if you see, there is no possibility of finding the accused, and the case is one which may not be tried in his absence. So, anyways, there are grounds. There are grounds. If those grounds exist, then the public prosecutor can refuse to institute proceeding. So, you see, among holding of preliminary inquiries among the powers of the public prosecutor. Among the powers of the public prosecutor is holding of preliminary inquiry. Okay. So using this power, the public prosecutor may decide that preliminary inquiry should be carried out. But public prosecutor will hold preliminary inquiry to be carried out irrespective of offences which are triable by the High Court only. This is a point. That's an important point. Public prosecutor can hold preliminary inquiry to be carried out irrespective of only offences that are triable by the High Court. Otherwise, if the offence is triable by the first instance court, preliminary inquiry cannot be carried out at all. Preliminary inquiry cannot be carried out. So, this is the other power of the public prosecutor. So, let you go back to Article 80. Sub-Article 2. Accused of any other offence triable only by the High Court, no preliminary inquiry shall be held unless the public prosecutor under Article 38 sub-article B so directs. It means that it is the power of the public prosecutor. If the public prosecutor thinks that preliminary inquiry should be carried out, then preliminary inquiry may be carried out. Otherwise, it is not mandatory for all offences triable by the High Court, preliminary inquiry to be carried out. So, in respect of all offences, preliminary inquiry will not be carried out. Even though it is under the jurisdiction of the High Court, if the public prosecutor believes that preliminary inquiry shouldn't be carried out, then preliminary inquiry will not be carried out. But the public prosecutor doesn't have such power in respect of these two offences. In respect of these two offences, preliminary inquiry is mandatory unless, as I said, the court is convinced that the trial can be held immediately. Okay. Then sub-article 3 is just about young offenders. Skip that. Article 81, court having jurisdiction. So, when will the preliminary inquiry take place? Then what is preliminary inquiry? What is the procedure of preliminary inquiry? We will look at right now. Article 81, court having jurisdiction, without prejudice to the provisions of Article 99 up to 107, the preliminary inquiry shall be held before the Warada Gazette Court within whose area of jurisdiction the offence was committed. Warada Gazette Court, the equivalent one now is first instance court. On the federal level, Warada Court in states or regions. Okay? So, preliminary inquiry takes place here. Preliminary inquiry takes place in the first instance court, if it is federal, Warada Court, if it is in states. Okay? But mind you, the offense is triable by the High Court. Okay? Okay, so, procedure Article 82. So, Article 1. All preliminary inquiries shall be held in the manner provided by the following articles. Sub-article 2, an adjournment may be granted on the conditions laid down in Article 9 in the following. Article 83, opening of preliminary inquiry. Here is the procedure. Article 83. Okay, read Article 83. I shouldn't rush. Opening of preliminary inquiry. Sub-article 1, where the public prosecutor decides under Article 80, sub-article 2, that a preliminary inquiry shall be held, he shall send a copy of his decision to the World Exile Court having jurisdiction and, where appropriate, to the public prosecutor acting before such court. You see, why do you think that the court, the law singled out Article 80 sub-article 2? What about Article 80 sub-article 1? What about Article 80 sub-article 1? So Article 83 sub-article 1 is talking about what the public prosecutor should do whenever he is exercising his discretionary power. As I said, in respect of the two offenses, preliminary inquiry is mandatory, except in exceptional cases that I mentioned. In other cases, it is a discretionary power of the public prosecutor to hold preliminary inquiry. So if the public prosecutor decides under Article 80 sub-article 2 that a preliminary inquiry shall be carried out, then he should send a copy of his decision to the World Court, because as I said, it is an offense that is triable by the High Court. You see? Triable by the High Court. But it is something that takes place before the trial, mind you. It is a pre-trial process, by the way. It is a pre-trial process. So he will send his decision to the World Court, and if necessary, says, to copy of his decision to the public prosecutor acting before the World Court. What the article says. Then, sub-article 2, the court shall fix the day on which the inquiry shall be held and cause to be summoned such witnesses as the prosecutor may wish to call in support of the prosecution. So, the public prosecutor will list the witnesses. Witnesses. Who will appear on the date of trial? Who will appear on the date of trial? So, he will, if you are a public prosecutor, and if the offense, in your opinion, is within the jurisdiction of the High Court, and if you believe that preliminary inquiry should be carried out, then what you will do is, you will send to the first instance court, if it is a federal jurisdiction, or if it is in Jima, for example, to the World Court. To the World Court. Your decision to conduct a preliminary inquiry. So you write an application to the World Court. Mind you, you are a public prosecutor before Jima Zone, Justice Speaker. It is, the offense is triable by Jima Zone High Court. So you will send your decision to conduct a preliminary inquiry to the World Court. You will write. And you will also list witnesses. Name of witnesses. Who will appear on the date of trial? It means, at this stage, you are preparing for the charge. It means, you are preparing the charge, mind you. So you have a list of witnesses. So you will jot down the list of witnesses and you will send to the World Court. So the World Court, on receiving that application, will immediately summon the witnesses. The court will fix, the World Court will fix the date of the preliminary inquiry. The date of the preliminary inquiry. By the way, the World Court is called committal court. Committal court is called committal court. So this committal court or the World Court will fix the date of preliminary inquiry. And it will issue summons to the witnesses so that they should come on the date of preliminary inquiry. Okay? Then, sub-article 3, the case for the prosecution shall be conducted by the public prosecutor acting before the committing court. So, the preliminary inquiry process will be led by the public prosecutor acting before the World Court or the federal first instance. Not you. Mind you, I said you are, for our example, you are public prosecutor acting before Jima Zone High Court, for example. You are working in Jima Zone Justice Bureau so that your jurisdiction is to take cases to Jima Zone High Court. Okay? So you will not leave the preliminary inquiry. You will send a letter to the World Court and that to the World Court so that public prosecutor acting before this Warada court will process the preliminary inquiry. And in your application, you will write the name of witnesses who should come on the date of preliminary inquiry. So this court will immediately issue summons to these witnesses so that they should come on the date of preliminary inquiry. Now let me come back to my earlier question. Why is the law singled out Article 80 sub-article 2 instead of Article 80 sub-article 1? What about instead of offences of homicide in the first degree and aggravated robbery? Why it's skipped? Does it mean that there is no preliminary inquiry? We already clearly said there is preliminary inquiry. You know the difference is in that case it is the court which processes that. It is the court. You know, it is the court. Whenever the offense under question is homicide in the first degree, or aggravated robbery, then the public prosecutor will file application to the High Court explaining that preliminary inquiry shouldn't be carried out, so that the trial should continue. Like he may file a charge, for example. So the High Court, looking at the charge, will not allow the public prosecutor to proceed with the case. Unless the court is satisfied by the public prosecutor that the trial can proceed immediately. So, if the court is satisfied, then the trial will continue. Otherwise, it is this High Court that refers the preliminary inquiry to be carried out. So it is not the public prosecutor's discretionary power. That's not a public prosecutor discretionary power. Article 80 sub-article 83 sub-article 1. Article 80 sub-article 2 or Article 80 sub-article 1 ጊዜ በፍርድ ቤት ነው ፕሮሰስ የሚደረገው። ማንዳቶሪ ነው። በቃ ፓብሊክ ፕሮሲኪዩተር ስለፈለገ አይደለም። ማንዳቶሪ ነው። ማንዳቶሪ ነው። ፍርድ ቤቱ ራሱ ፕሮሰስ ያደርጋል። አንለስ ፍርድ ቤቱ ሳቲስፋይድ ካልሆነ ፓብሊክ ፕሮሲኪዩተሩ አይ ቶሎ ይቀጥላል ምናምን ካለ እሺ ብሎ ፓብሊክ ፕሪሊሚናሪ ኢንኳሪ ይደረግና ትራያሉ ይቀጥላል ማለት ነው። ሆኖም ግን ፍርድ ቤቱ ሳቲስፋይድ ካልሆነ then በሁለቱ ኦፌንሶች ጊዜ ግዴታ ነው preliminary inquiry ይካሄዳል። ፓብሊክ ፕሮሲኪዩተር ቻርጅ ሊያስገባ ይችላል፣ ግን የግድ ፍርድ ቤቱ ሪፈር ያደርግና preliminary inquiry ተጣርቶ ይመጣል። then preliminary inquiry ተጣርቶ ሲመጣ ቻርጅ ይቀጥላል ማለት ነው። that is why እዚህ ጋር ግን ዲስክሬሽነሪ ፓወር ስለሆነ አቃቤ ሕጉ የሚጠበቅ ነገር ስላለ አቃቤ ሕጉ ፋይል ያደርጋል ፍርድ ቤቱ በታች ፍርድ ቤት አቃቤ ሕጉ ነው የሚቀጥለው ማለት ነው። ዲስክሬሽነሪ ፓወር irrespective of other kinds of offenses. Okay, it will be clearer as we go deep into the provisions. Please. Before taking evidence for prosecution. Article 84. It is talking about the procedure of preliminary inquiry. Now, mind you, preliminary inquiry is definite. Okay? Public prosecutor, ወይም በፓብሊክ ፕሮሲኪዩተሩ ወይም በፍርድ ቤቱ ራሱ ምክንያቱም ኦፌንሱ አርቲክል 539 ስለሆነ ሊሆን ይችላል። ኤኒሃው ፕሪሊሚናሪ ኢንኳሪ የሚካሄደው ሃይ ኮርት ላይ አይደለም፣ ወረዳ ኮርት ላይ ነው። ወረዳ ኮርት ላይ ልክ አፕሊኬሽን ሲደርሰው ወይ ፍርድ ቤት ቀጥታ ሊሆን ይችላል ወይ በፓብሊክ ፕሮሲኪዩተሩ ሲደርሰው ፍርድ ቤቱ የወረዳው ፍርድ ቤት ወዲያው ፕሪሊሚናሪ ኢንኳሪ የሚካሄድበትን ቀን ይወስንና መጥሪያ ይልካል ለሰሞንስ። ምክንያቱም ፕሪሊሚናሪ ኢንኳሪ አፕሊኬሽኑ ላይ የዊትነሶች ስም አለ። ስለዚህ እናንተ እንደዚህ ገሌ ለዚህ ቀን ስለምትፈልጉ ለቀዳሚ ምርመራ ወቅት እንድትቀርቡ ብሎ ሰሞንስ ይልካል ማለት ነው። እዛን ቀን መምጣት አለባቸው። they have to come. Then what will follow on that date? Article 84, taking evidence for prosecution, it says. Taking evidence for prosecution. Where the accused person appears or is brought before it, the court shall require the prosecutor to open his case and call his witnesses. So the accused person should appear on the preliminary inquiry court. So, where the accused person appears or is brought before it, the court shall require the prosecutor to open his case and to call his witnesses. So the case is open. So it is the public prosecutor who decides the case, who begins with the case. The court will order the public prosecutor to open the case and to call his witnesses. Mind you, the witnesses have already been called by the order of the court. They have been summoned. So they have to appear on the date fixed by the court, by this court. Okay? Then, Article 85, accused asked whether he wishes to make a statement. So the public prosecutor calls witnesses. So the witnesses will be called. Maybe 10 witnesses, 15, what have you. So they will come, they will be called, and they will come in court.